Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen, and welcome to this webinar on the first steps towards GDPR compliance. I'm Alan Calder. I'm the founder and executive chairman of IT Governance. I'm going to be your host for this afternoon. We've got just about an hour, and my own background is in general business management. I set up IT Governance about 12 years ago to be a single source for everything that an organization might need to tackle the requirements of data protection and cybersecurity. The books I've written have gone on to be useful in a number of areas, but out of those books has grown a business which provides a range of services that includes consultancy, training, software tools, toolkits, books, publications, and the whole range of things on which an organization might need to draw if it's seeking to become compliant with the requirements of GDPR. And GDPR comes into effect on the 25th of May. So on the one hand, you may well be looking at it in a sense of some trepidation, thinking how, if you haven't started on the project, do you get from where you are today to the point of compliance in the time remaining? And the answer is that as long as you get started, you will have started. It may by now, if you haven't already started, be impossible for you to be fully compliant by the 25th of May. But the point about GDPR is it's not a destination, it's a journey. Having got it started on your route towards compliance, the program of embedding data protection by design and by default inside the organization is likely to take significantly longer anyway. The important thing is that you do get started and you do accelerate your journey towards compliance. So I can talk briefly about the regulatory landscape, the territorial scope of GDPR. We'll look at the principles, the breach notification rules, data subject rights, changes around consent and alternatives to consent as a lawful basis for processing data, the liabilities on processes and therefore the importance for being clear as to whether in respect of each area of processing you're a processor or controller, the role of the data protection officer, international transfers, and then briefly regulators and pan-European consistency for a regulation which is designed to produce a level playing field across the 28 member states. I'm going to talk for about 45 or 50 minutes. I'm sure that you will find yourself with questions as we go through this. Please do use the question function in GoToWebinar, which should be sitting on your screen. Do type questions into that as we go along, and then when we get to the Q&A session, what I'll do is I'll read out the questions so everybody know what the question is, and then I'll give you my answer, and I'll get through as many of those as we can in the time that's left before this webinar is due to finish. So the important thing to know about GDPR is that it's a regulation. European legislation is divided, broadly speaking, into directives and regulations. Directives are the European Commission telling member state governments what type of law they need to produce. The Data Protection Directive, which led to the Data Protection Act in the UK, is an example of just that. And as long as the member states do the minimum, the directive sets they can do whatever else they want to do, and they can do it in their own style and so on. A regulation, on the other hand, goes into law as written in every single member state. Member states may have be able to take advantage of derogations, which say this is an area in which you can adapt the law to suit your own specific requirements. But broadly speaking, a regulation in whichever official language it's translated into is the same set of requirements, and it's to be implemented in the same way in every single member state. So GDPR is the first pan-European data protection law that sets out a consistent set of requirements in respect of how personal data is protected. The model for data protection looks a bit like this. There are data subjects, that's us. We own our own data is the starting point for GDPR. And if we choose to share it with a data controller, the data controller is the organization that determines the means and purposes of processing data, then the data controller is going to have obligations to us in respect of that data. A data controller can outsource some of the processing. When it does this, the third party to whom it outsources processing is defined as a data processor, and data processors are for the first time legally defined with legal obligations into GDPR. You can also transfer the data to a third country, i.e. not the country within which the data was collected, and in both of those cases there are specific obligations on you. Not only can you collect data from the data subject, but you can also collect it from third parties, and you can share it with third parties. So pretty well whatever you do at the moment is still possible. What GDPR does, though, is say that there are a particular number of things you have to do in order to do it legally. Nothing in GDPR which says that most normal proper business practices can't continue. All GDPR is saying is that you have to do it in a way that complies with the law, and if you don't, you run the risk of a significant set of fines. So data controllers have duties in respect of data subjects. Data subjects have rights, and it's the role of the Information Commissioner in the UK, who's the UK version of a supervisory authority, and every member state will have a minimum of one or a lead supervisory authority to enforce the GDPR. That means the range of powers stretch from levying fines all the way through to advice and guidance, assessment, and so on. So it's a very significant role for the Information Commissioner, who is also going to continue having a series of responsibilities under other UK and European legislation. So that's the model of data protection. In order to ensure that it's applied consistently across Europe, GDPR creates the European Data Protection Board, which is not a super regulator. It's an entity which exists to iron out deviations in interpretation of the law to ensure that it's applied consistently across all member states. So it should genuinely be a level playing field for companies and a level playing field for data subjects. And a data subject is a natural person, a living individual. A corporation can't be a data subject because it's an imaginary entity. A living person is. So by definition, people who've deceased no longer have rights. Natural persons have rights associated with the protection of their data, the protection of the processing of that data, and the unrestricted movement of their data within the European Union. And within the scope of GDPR is any personal data processed wholly or partly by automated means, or that is part of or meant to be part of a filing system. So pretty well any form of data on paper or in digital format is going to be captured, and the definition of personal data includes anything that can identify a natural person. So anything health data, genetic data, biometric data, locational data, IP addresses, all of those that might address a natural person are personal data, and they're within scope for GDPR. And it applies to controllers and processors based in the European Union, irrespective of where their processing takes place. So if you're in the European Union and you're selling things across a website to customers in Africa, all of those customers have the same protections as do anybody else, because by virtue of the fact you're in the European Union, you have to comply with GDPR. It also applies to controllers and processors not in the European Union, but that are providing services into the European Union. So if you are a US e-commerce business and you are selling products into the European Union, and it's obvious that you are because you take payments in euros or you accept shipping addresses in France or Germany, then you too have to comply with GDPR. The requirement is in terms of where organizations are based, not in terms of the type of people that might be within scope, because GDPR in one of the recitals says clearly that the processing of data is to be protected irrespective of the nationality or place of residence of the data subject. And organizations that fail to comply with GDPR face a range of fines, administrative fines. The administrative fines, there's a range of, if you like, a tariff. For lower level fines, the maximum is 10 million euros or 2% of global turnover. And for more significant breaches, which are usually to do with the breach of the data processing principles, breach of the rights of data subjects, or breach of the rules around extraterritorial data processing, those fines can go up to 4% of global turnover or 20 million euros, again, whichever is the higher. I'd stress they are up to fines. That's not what the fine will be. The supervisory authorities are required to properly investigate and take account of the extent of negligence of the organization that's in breach. And so everything that an organization has done to reduce its negligence has to be taken into account. Fines have to be dissuasive, but they also have to be proportionate to the transgression and to the organization itself. So potentially a significant danger. And the two ways in which an organization can get into trouble, you don't want to be thinking about, will the supervisory authority come and audit me? That may well happen, but it may well happen further down the track. The more immediate dangers for organizations are that you're required to report any data breach to the supervisory authority within 72 hours of first becoming aware of it. And if it takes you the UK average of 146 days to become aware of it, you can be sure you've got a lot of explaining to do about how you're not negligent in being unable to identify you've been breached. So you've got to report a breach within 72 hours of becoming aware of it, unless there is no risk to the rights and freedoms of data subjects, in which case you don't need to report it. You'll also need to report it to the data subjects if there's a high risk to their rights and freedoms. Of course, if you're reporting a breach to the Information Commissioner, it's likely that she'll want to investigate why you've had a breach. So data breach reporting, and a data breach, a personal data breach, is basically any compromise of the confidentiality, integrity, or availability of personal data, the data not being available for the purposes for which it was collected. If you can't report within 72 hours, you've got to explain that as well. So reporting data breaches is a critical issue. The second way you get into trouble is that data subjects have rights, and data subjects are entitled to bring complaints to supervisory authorities or to bring actions in a law court where they feel that their rights have been transgressed. And either of those, apart from the problems that dealing with those might cause, of course, there will also be the cost of dealing with them, and the fact that you've got an action successfully brought against you may well lead the supervisory authority to carry out an investigation anyway. So the immediate risks are you've been breached or someone brings a complaint. The longer term risks are that there is an investigation, perhaps an investigation of organizations in the sector of certain sizes, which exposes the fact that you're not in compliance. For those wondering why there isn't a longer transition period, the answer is there has been. We're in the last couple of months of a 2-year transition period. It was passed into law in April 2016, published in May 2016, and entered into force on the 24th of May 2016. It becomes effective on the 25th of May 2018 as a result of a 2-year transition period. And it comes into force everywhere by virtue of European Union treaties. So even though the UK is currently in the process of passing a new data protection bill, if it passes or not doesn't change the fact that GDPR comes into force on the 25th of May. The reason the UK government is passing its own bill is to enshrine European regulations in British law. The British law won't change any of those bits of the regulation which are common for all member states. There are areas in which the UK is amending the law where it's allowed to, because a derogation exists for that. But that will enshrine GDPR in British law beyond Brexit, which it is to be hoped helps Britain achieve an adequacy finding for the export of data post the post the point of Brexit in 2019. So it comes into force in just about 2.5 months' time, 2 months' time. And so organizations, if you're not started yet, you're thinking, what do I do now? The answer is you're going to get started and get moving as quickly as possible. The reality is you may not be able to get yourself compliant in time, and that might mean that what you have to do is everything you can with a clear program that takes you to compliance at some point further on. Deal with the obvious risks, data subject access requests, cybersecurity, and so on. Bear in mind the starting point for GDPR is the rights of data subjects. And so the requirement in Article 11 is the controller. The controller is the entity that determines the means and purposes of processing, has to take appropriate measures to provide data subjects with any information they might need so they can understand what processing of their data is going to take place. Got to be easily accessible, got to be in clear, straightforward format. And at the point of telling people what you're going to do with their data, you also have to tell them what their rights are. And having told them what their rights are, you have to put processes in place to facilitate the exercise of those rights. And those rights include the right to know what you're doing with their data, the right to rectify errors, to have data raised if there's no longer, if the purpose which was originally collected no longer applies, to restrict processing during a period of objection, to object obviously to processing under specific conditions, to get data given back to you in a machine readable format, or to have it ported to an alternative organization within the European Union, and to be informed of any automated decision making, which is likely to have specific consequences for the data subject. So very specific rights, they're enshrined in law, and you have to, as a data controller, ensure that you've made it possible for data subjects to exercise each of those rights. If you're relying on consent as a lawful basis of processing, they've got the right to withdraw consent at any time, and that's the point at which you should stop the processing. So data subject rights and the 6 data processing principles, you can think of them as, in a sense, the controller's mirror image or the controller's response to data subject rights. Controllers have to process data lawfully, fairly, and in a transparent manner. I'll talk briefly about lawful basis of processing shortly. The data must be collected for specific, explicit, and legitimate purposes. And frankly, if you can work out how you're going to do principle 2, what the specific, legitimate, and explicit purposes are, it'll probably be quite easy for you to put in place all of the other data processing principles, because the data that you collect must be adequate and limited to what's necessary for that purpose, must be kept accurate and up to date for that purpose, retained only for as long as necessary for that purpose, and protected in a manner that's appropriate to that purpose to maintain its security. You can't, under GDPR, collect data for one purpose and then decide that there are a couple of other things you'd like to do with it and not tell the data subject. There's a mechanism by which you can say, I want to do something differently with the data and have a conversation with the data subject. But essentially, the driver is, what is the purpose for which this data has been collected, and how do we tell the data subject, and how do we then build our systems to ensure that that's what we do. GDPR doesn't just say there are 6 data processing principles, it says there's an overriding principle, which is really the principle of accountability. Organizations are accountable for ensuring that the data protection, data processing principles are applied across the organization. Accountability must start with the board and senior management, must be therefore built into roles and responsibilities. And the Information Commission in the UK over a year ago, is very clear that accountability really means a requirement on organizations to build a culture of privacy that pervades the entire organization. GDPR, she said, mandates organizations to put in place comprehensive but proportionate governance measures to ensure that GDPR becomes part of the company's overall system approach to how it manages and processes personal data. So the Information Commission is saying very clearly that GDPR is not about a set of boxes that you can tick. It's about building data protection into the whole fabric and culture of the organization. You have to recognize that that's a multi-year project. You're trying to do with protecting personal data. What most organizations have successfully done around health and safety of employees has become a fundamental part of how the organization operates. So applying the principle of accountability, of course, means corporate risk register, a nominated responsible director on the board who's able to keep the board up to date with progress and beyond the 25th of May with ongoing compliance, clear roles and responsibilities through the organization, possibly a data protection officer if you fall into one of the categories of organizations for which a DPO is mandated. Frankly, if you don't, you'll still want to have somebody who is charged with the role of GDPR compliance. And you'll want to build a privacy compliance framework, a combination of a personal information management system or a PIMS and an information security management system, which ensures that you're managing the documentation and the security of personal data. You have to have records of processing. Those are a requirement of Article 30 of GDPR. You need a cyber incident response and data breach reporting process. If you remember the requirement to report breaches in 72 hours or as soon as you are aware of them, that's not the point at which you want to be working out how to respond to a breach. You need to have put in place something which is tried and tested. Standards like Cyber Essentials, which is a UK government approved security standard, you should think of as a minimum security standard, a minimum way of demonstrating the organization has paid basic attention to security, has put something in place which is capable of giving both management and stakeholders a level of assurance that basic cybersecurity is in place. And you should keep an eye open for the emergence of data seals that might deal with different parts of data processing, and consider the possibility of ISO 27001 certification. ISO 27001 is the International Information Security Management System standard, as another method of demonstrating that as an organization you have taken appropriate steps to meet the compliance requirements of GDPR. We don't believe that there ever will be, there might, but we don't believe there ever will be, there certainly is not at the moment, any mechanism for an organization to certify as being GDPR compliant. You can do things that to the best of your knowledge make you compliant, but the reality is that compliance is going to be a decision made in courts, and compliance will emerge as a decision after an argument between two parties over what a particular term in GDPR means. What GDPR does look for is data protection by design and by default. And the logic of how you get there starts with a data flow audit, mapping a data flow, identifying how you comply with GDPR, how the 6 data processing principles apply in that data flow, where you're dealing with high volumes of special categories of data, doing a data protection impact assessment. And DPIAs are mandatory for a number of organizations, pretty much like DPOs are mandatory for a number of organizations. Not mandatory for everybody, but certainly where you're putting in place a significant new system or changing a existing system that might bring risks to data subjects, you should be considering doing a DPIA. So the principle of accountability is a very broad principle, and it's a key part of your GDPR compliance program. Article 6 deals with lawfulness, and lawfulness in simple terms is saying unless you've got a lawful basis for processing personal data, you can't process it. And the options are relatively straightforward. The most common option at the moment that organizations use is consent, but consent is not under GDPR likely to be always the best option. In fact, you might think of consent as the option that you go for when you can't identify one of the other options as being appropriate. For instance, consent is not a valid basis on which to process the data of an employee. And it's not a valid basis because the relationship is not equal, and consent, if it's to be given, has to, under GDPR, given freely and fairly between parties of equal standing. So employment contracts need to be redrafted. You need to shift away from consent in employment contracts, and you need to move to a range of different consents which are granular and relate to each of the different types of processing. So you might need name and address and other information in order to fulfill a contract. You need somebody's payment information in order to fulfill the employment contract, but you will keep and retain their national insurance information and their wage information in order to meet your statutory obligations to maintain proper accounting and HMRC records. So pursuant to a contract between a controller and a data subject, statutory obligations, data required by a court case, legitimate interests of a controller in collecting data in order to protect against cybercrime or as part of a direct market. Those are all legitimate interests. Those are alternatives to consent, and you can select any one of those as long as you can meet the test. If you can't, then you've got to go and look at consent as being the lawful basis for processing. Where consent is the lawful basis, there's a very high bar for consent. I'll come back to that, but it's the role of the controller to determine what the lawful basis of processing is. The controller, as I said, is defined as the entity that determines the means and purposes of processing. A processor is a third party acting on behalf of a controller. Processors may not legally process data other than within a contract from a controller. So if you think you're a data processor, then you need to identify for that data who the controller is, and you need to talk to them about giving you a contract which sets out what you do, including how you return the data to them at the end of the processing, and then you need to abide by that contract. If the reality is that you might be a supplier to a particular organization, but actually you're determining what personal data you collect from them, then you could be a controller to that organization, not a processor. You need to get clear in terms of every single one of your relationships what your role is, and the controller processor logic applies at a process level, not just at an entity level. So that's a key part of thinking about lawfulness. Am I a controller in respect to this data? If so, what's the lawful basis I'm going to select? And then how do I tell the data subjects? If you're left with consent only, consent in Article 7, you have to be able to demonstrate that consent was given. Consent has to be positive and affirmative, so inactivity, pre-tick boxes, consent by default, those all become illegal on the 25th of May. You need to make sure that websites and every other place where you might be relying on that is gone. You also need to look at data which you previously gathered on the basis of consent by default. You'll not be able to maintain it on that basis after the 25th of May. You need to think about legitimate interests or one of the other number of bases there might be for you to retain that data, but you need to get your existing data into GDPR shape by the 25th of May. If you're relying on consent, you have to be able to demonstrate that consent was given and that you provided clear information that enabled the data subject to know what they were consenting to. Under 16 years old, generally in the UK, the derogation will be under 13 years old, says that people under that age can't legally consent to the processing of their data for the purposes of an information society service. That doesn't mean for everything. It simply means, for instance, for social media services and for online e-commerce services, anything which is an information age service. A child can't consent to the processing of their personal data, which means that if you're providing service in that area, you need to think about how you will ensure that the data subject is of an age that they can consent. They haven't simply got a friend in to pretend to be an adult. The bigger challenge comes with what are called special categories of data, what used to be called sensitive information. And GDPR says that you may not, it's prohibited to process special categories of data unless you've got one of the exceptions to that prohibition, which are listed in Article 9. Special categories of data, things like race, ethnic origin, political beliefs, health information, biometrics, genetics, all of those kinds of areas. And you may not process that unless you can identify explicit consent from the data subject to the processing, or a vital interest of the data subject, or a number of other possibilities. And so getting really clear about what special categories of data you're processing and the exception on which you're relying, and documenting all of that, is another key part of your GDPR program. One of the big themes of GDPR is transparency. We see it in the requirements that you're clear and open with data subjects about the processing you're doing. Any communications must be concise, transparent, intelligible, with the controller providing adequate information about data subjects. And that particularly flows through in terms of data subject access requests. There've always been subject access requests in the existing data protection framework, but under GDPR, you will have 1 month to respond, and you will not be able to charge a fee for doing so. So a data subject access request, you can provide them with whatever data they're looking for. You have to make sure that you're able to identify the person as being whoever they claim to be, and you have to be able to make sure that you don't share with them data that belongs to some other party. So redaction and so on is a part of your response process. As I said, you need to be very clear in dealing with data subjects. They have a number of other rights, and you need to set out to them how you will help them exercise those rights. After Article 25, GDPR talks about the idea of data protection by design and by default, the idea that you build data protection into your data processing activities at the point that you're designing the data processing activity. So you think about that in terms of IT projects, system projects. How do we deal with data protection has to be part of the initial planning. When you're looking at outsourcing activity, you have to be asking whether the third party has the appropriate controls in place. You're moving it outside the European Union, the same thing applies. Those organizations outside the European Union providing services into it have to appoint a representative inside the European Union. And as we've said, data protection impact assessments are either a good idea or in some particular areas mandatory. Certainly data audits will become a standard ongoing part of your compliance regime, making sure that the data that you're processing continues to be processed in accordance with the requirements of GDPR. You need to identify the data you've got. You need to make sure that it's being processed in accordance with the GDPR and that it's secure. The sixth principle talks about protecting personal data. Article 32 also talks about protecting personal data. And putting those both together are best served by recognizing that the organization needs to have appropriate security. That means you need a risk assessment methodology. You need to be able to determine high risk, and low risk to the rights and freedoms of data subjects. You need to be able to work out how to select appropriate technical or organizational measures. GDPR doesn't tell you what controls to put in place. You've got to determine those for yourself. And the appropriate controls could be pseudonymization, could be encryption. Encryption is a good thing to be thinking about because it, as things stand, reduces the risk of exposure from a supervisory authority point of view to minimal, so that you don't have to report a breach to the supervisory authority if the data was encrypted. Regular penetration testing, evaluating the effectiveness of your security measures, all of those should be a key part of data protection by design. Cyber Essentials, ISO 27001, as I've already said, indicate that you've applied known best practice to demonstrate that you've taken appropriate steps to secure data. And putting together your privacy compliance framework that draws on how you deal with information security, Article 32 and Principle 6, how you deal with the documentation, all the other 5 data processing principles, and how you link that to your governance, risk management and compliance framework is a privacy compliance framework. And building one of those inside an organization with documentation that's appropriate to the scale of the organization, of course, is at the heart of an effective GDPR maintenance program. So your implementation program is trying to build a PCF, maintaining GDPR compliance is about ensuring the PCF continues to work effectively. For many organizations, the data protection officer is going to be at the heart of your GDPR compliance activity. Data protection officers are mandatory for organizations processing substantial volumes of personal data, special categories of personal data. It's also mandatory for organizations, for public authorities and organizations processing high volumes of data in public places, and it's a good practice appointment outside of that. If you appoint a DPO, whether they're a good practice appointment or not, they are subject to the same protections as the mandatory DPO. That means you can't fire them if you don't like their advice. It means that you can obviously fire them if they otherwise don't comply with their employment contracts. You have to listen to them. They have to have access to top management, and they can't be conflicted. Somebody who has a role in determining the means and purposes of processing can't also, by law, be a data protection officer in that organization. If there's no mandatory reason to have a data protection officer and you call the role a GDPR compliance officer, we can't see any reason why the requirements of DPOs fall on that kind of a role. Most staff inside the organization are going to need some form of training. HR, marketing, sales, all of those people who are involved in processing data will need to know what their obligations are. And of course, staff generally will also need to have training around how they deal with data, how they recognize a subject access request, and so on. Touched on certifications. They're how you demonstrate that you've done the best you can. You've taken those standards or codes of practice that exist and you followed them, and that enables you to demonstrate that you've not been negligent. But of course, a certification doesn't absolve you of the need to actually comply with GDPR. So you might have an ISO 27001 certificate and not be complying with GDPR. You need to tie ISO 27001 controls into the objective of protecting the rights and freedoms of natural persons. Big risk area, particularly in this era of cloud-based computing, is international transfers, and any transfers of data outside of the country within which it was collected can only be done subject to the requirements of GDPR. And that is, first of all, it's going to a country which has got an adequacy finding. The rest of the European Economic Area meets those criteria. Otherwise, it can only be done on the basis of appropriate safeguards. Safeguards could be binding corporate rules, could be standard contract clauses, or could be some other adequacy mechanism. America, for instance, is a country which, because it doesn't have a national data protection framework, is not a country that has or is likely to have an adequacy finding in its favor from the European Commission. We did have something called the Safe Harbor framework in place that enabled US organizations to effectively claim that they were operating within an EU-like environment, but that was pulled down and has now been replaced by something called the EU-US Privacy Shield, which is a more rigid mechanism and framework that US organizations can register to as a method of demonstrating that they are complying with the Data Protection Act requirements of the European Union. That still has to be brought into line with GDPR. The current requirements are still very much Data Protection Act or Data Protection Directive oriented. All countries, as I said, have an independent supervisory authority. The independent supervisory authority has to be funded by the government, has to have a budget adequate to its tasks. We think it's highly unlikely that any supervisory authority will be allowed to keep the money that comes from fines, because that creates an obvious conflict of interests. And supervisory authorities' tasks include monitoring the application of GDPR, communicating it, promoting awareness, and of course enforcing it. The other thing to be aware of when we're looking at supervisory authorities is that those organizations operating in multiple countries across the European Union can select to deal simply with one supervisory authority, to have a lead supervisory authority for all of their pan-European activity. There is a challenge for Britain because assuming that Brexit happens, Britain will be outside the European Union. There's not yet any certainty that there will be a finding of adequacy in respect of Britain, nor is there any certainty that if you've chosen the UK as your lead supervisory authority, they will continue to be able to act in that role beyond Brexit. And that's because GDPR is explicit that a lead supervisory authority has to be a supervisory authority of an EU member state. So there's an awful lot for British companies still to have to deal with that is unknown in terms of pan-EU trading in respect of how they handle personal data. The European Data Protection Board, as I've said, exists to ensure cooperation, communication, and consistency amongst the 28 member state supervisory authorities. It's being created out of what's called Working Party 29, which is the working party, the European Commission working party that's been responsible for developing and deploying the GDPR regulation. The Information Commissioner's final words on the subject really were to say accountability requires an upfront investment. it's got to be good for you, got to be good for your data subjects, employees, customers, and so on. So it's a good thing to be doing. But hey, if you can't see the positive, the upside of being accountable of GDPR, then don't worry, because we've got a big stick and we've been very happy, as you've known, to pursue typical data breaches. And bear in mind, it's not just the data breach that we pursue, it's in reality the investigation which exposes the underlying level of negligence that causes the actual size of the fine. So the message from the ICO is, don't think that a fine will be linked just to a minor transgression. It will be linked to the core negligence. But the other message, which has been clear from the Information Commissioner in the UK for some time now, is don't expect her to be levying very large fines immediately. What she's looking for is to encourage organizations to continue making progress towards compliance, looking for evidence of non-negligence. We think there will be some variation in that approach across Europe, frankly, but the reality is that even if an organization breaks the law on the 26th of May, there's still a period during which there will have to be investigation, there will be a determination of a fine. So the earliest fines we would expect under GDPR may be towards autumn or the end of 2018. In any case, the fact that there isn't a fine on the 26th of May shouldn't mean the time has come to take it easy. It just should mean that you've got another day closer towards the point at which you can begin thinking about embedding data protection by design and by default. So your program starts with a governance framework, board awareness, a risk register, a proper accountability framework through the roles that are going to have to deal with GDPR, appoint and train either a data protection officer or a senior person responsible for GDPR compliance. Find out what personal data you've got. Do a data inventory, work out what data you're holding unlawfully. This could be information that you've held for the last 10 or 15 years, could be boxes of personal data. Destroy it, remove it, get clear what changes you need to make to the lawful basis of processing data. Do a data flow audit. Identify how data is collected, what it's used for, where it goes, who has access to it, because all of those will expose areas in which you need to make changes to what you're doing. Your gap analysis will lead you to identify changes that you need to make to privacy notices, to your data subject access request process, to your contracts with suppliers, with customers, and of course to employment contracts as well. You need records of processing, a description of what processing you're doing, what security measures you have in place, and you may well need to look at doing a data protection impact assessment and a gap analysis around your cybersecurity. You might be thinking quite quickly, if you don't really have ISO 27001 or Cyber Essentials, how you can bring frameworks like those in and tie them to the protection of personal data. Remediate, do all of the changes that you need to do, build out the privacy compliance framework, make sure you've got a tested and robust data breach response process, make sure that when somebody downloads a piece of ransomware, you're able to identify it quickly, isolate the machine, identify whether any personal data has been compromised. If it has, know how you're going to report the breach, bearing in mind that most data breaches, significant ones, happen on Fridays, usually just as the IT team is heading off for its hard-earned weekend. And that's designed so that the hacker gets the weekend to do with whatever they will, but your 72 hours is a calendar 72 hours. So if you're breached on a Friday afternoon, you're reporting the breach to the supervisory authority on Monday. You don't want to just be finding out about that on Monday when you return to work. So test your data breach response process and then build out a process for monitoring, auditing, and continually improving your ISMS, your privacy compliance framework, to make sure that over time GDPR becomes more and more embedded in the way in which the organization is addressing its GDPR requirements. As an organization, there's a whole bunch of ways that we can help. We have books, pocket guides, manuals, documentation toolkits, a gap assessment tool. There's a range of foundation and practitioner training courses that you can use. There's a data protection impact assessment workshop, and there's a range of consultancy, gap analysis, data flow audits, data protection officer as a service, helping establish PIMs and ISMS, cyber health checks, a whole series of different interventions that you can draw on, designed for organizations of a range of different sizes. Above all, as I said, the key thing is to get started. If you haven't yet made a good start, don't delay. Get things moving, create a plan, put yourself in a position where if you do have to talk to the Information Commissioner in late May, you can point to the fact that you have at least made a good start on your program. And that brings me to the end, ladies and gentlemen, of what I was planning to say. So I'm going to take questions now. If you do have a question, please do type it into the question function in the GoToWebinar panel. What I'm going to do is go through, and in what time we've got, I'm going to answer the questions that there is time for me to answer. I'm going to read the question out, and then I'll give you the answer. So we work in the IT managed services and provide data backup, which involves us holding customer collected personal data. Would we have to implement anything extra to protect our business? Well, there's two things at least. The first is that you have employees, so you need to deal with the lawful basis on which you're processing employee data. You're probably doing it on the basis of consent that will be invalid. You have customers, so you have customer contacts, you have supplier contacts. All of that information needs to be dealt with. The idea that B2B information is outside GDPR is not true. Anything that identifies someone, so Alan Calder at itgovernance.com is personal information. info@itgovernance.com obviously isn't, that's a corporate address, but Alan Calder, that's me. So all of that is within the scope of GDPR. The second thing you need to do is recognize that you're a processor for this data, and that you need in your contract with your customers to have set out very clearly what your obligations are as a processor. The data backup, you will be doing what your customers tell you to do. Yes, you'll write for them what they're going to tell you to do. You'll help them with data subject access requests and so on, but you need to address very specifically your responsibilities as a data processor. We have a partner, and in order to provide the best possible experience for customers, we're exchanging the data. Can we continue with this practice? So you can continue exchanging data with partners as long as you have a lawful basis for doing that. You might be able to identify a legitimate basis or a subject contract basis. Without knowing more, I couldn't tell you. At the very least, you will need to issue a privacy notice which says very clearly to customers what you're doing. I suspect that you would only be able to rely on consent for this type of data sharing, in which case you need to be very explicit in terms of explaining to the data subjects who you're sharing the data with, why, what risks there are. But yes, business practices can continue. You have to work out how to do it in a way that's compliant. If we wish to share data with third parties, how do we obtain permission from the data subject for this? They usually fill in a form and tick to opt into details being shared with specified third parties. Well, ticking to opt in is good. That's positive consent, but you need, in the privacy notice, which is going to be connected to from that part of the website, to be explicit about which third parties, the purposes for which you're sharing the data, how the data subject can go about accessing their data, how the retention, what the retention periods will be, how those retention periods will be enforced. All of that needs to be in the retention period. You can't just say we're going to share this data with a few selected partners, hope that's okay by you. Are EU citizens living in non-EU countries covered by GDPR? Well, that depends. The regulation doesn't apply to EU citizens. It applies to controllers and processors. And so if a controller is based in the European Union, it has to comply. If the EU citizen is living in the EU or in a non-EU country and it deals with that organization, it will be protected. If you're an EU citizen and you go and walk into a business in Australia and you expect them to protect their data, they won't, because GDPR applies to controllers and processors either based in the European Union or providing services into the European Union. Who is responsible and what are the fines for voluntary organizations? GDPR doesn't distinguish between voluntary, not-for-profit, or private sector organizations. So any organization processing data has the same set of liabilities and responsibilities under GDPR. The Information Commissioner is the entity that will levy fines. She currently in the UK fines charities and not-for-profits for data breaches. That happens quite regularly, and that can be very difficult for organizations who rely on members to provide contributions, not to pay fines, but for a particular charitable cause. And so really charities should be making a major effort to become compliant. Who decides if the breach poses a risk to the individual's rights and freedoms? Technically, you do. The reality is that if your decision is a bad one, the supervised authority can override it. So you need a risk assessment methodology which enables you to determine properly what the risks to the rights and freedoms of data subjects might look like. And you need to be able to demonstrate that you've acted upon it. Expertise, do give us a call if you want to talk about what our expertise is in terms of fintech firms. We work with firms from all sectors. Being a small charity with a lot of data held on paper that we're currently trying to cut down, we're concerned about data subject access requests and the concerns that individuals may submit a SAR simply because they can. How do you deal with a SAR that says, my name is Joe Bloggs, I want to know exactly what data you hold on me? Are you able to ask why he wants that data and ask he knows what area it may be in? Well, technically, anybody's entitled to ask for the data that you're holding about them. You're not entitled to make it difficult for them. Remember the point about facilitating the exercise of data subject rights. You are expected to make sure that the person is whoever they say they are, so you do have to identify them conclusively. Giving somebody data that's about someone else but who has the same name would be a data breach, so you have to identify them conclusively. You're perfectly entitled to ask for guidance to help you identify where data might be or what type of information the data subject thinks it might be, but in the absence of guidance, you've got to go find the lot and give it to them. That's what GDPR says. It says the data subject owns their data. The controller's objective, the controller's responsibility is to make sure that the data subject's rights are protected. Yes, it applies. GDPR applies to all organizations, regardless of size. The only thing I would say is there is a derogation for organizations with less than 250 employees, which under certain circumstances, i.e. when there's not much risk to rights and freedoms, enables you to dispense with quite a lot of paperwork. Can data be pseudonymized in place of deletion with regard to the right to be forgotten? Pseudonymization is simply making information difficult to access. So no, pseudonymization is not a replacement to deletion of data under the rights to be forgotten. Anonymization would be, in the sense that anonymization removes data completely from the scope of GDPR because it's not possible in any way to identify who the data subject is once the data has been anonymized. Think of pseudonymization as a security technique. Think of anonymization as a method of removing data from the scope of GDPR, and think of deletion as a way in which you deal with the exercise of the right to erasure. Remember, the right to erasure is not absolute. Organization, there are circumstances under which you don't have to deal with it. Can you give some examples of data in relation to employees? So in relation to employees, you're processing their name, their contact details, their bank details. You're keeping records of what you've paid them over the years. You've got employee files with details of promotions. You may have next of kin information. That's all personal information. Customers, you're going to have contacts at your customers in their sales teams, or in their supply teams, in their procurement teams. All of those are personal data. You need to deal with that within the scope of GDPR. Does the right to data portability include all email and phone records, or just the information the subject supplied when they made the purchase or submitted a claim form? The data portability applies to data provided by the data subject in an electronic form. And they effectively have the right to get that back from you in a machine readable format to take to somewhere else. So as far as we're concerned that would include an X-ray which they took of you. That's their information they provided to you. It's an electronic form. They've paid you for the X-ray. They want to take the X-ray to another provider. They should be able to do that. A recording of this webinar will be available. Yes, which companies would be exempt from appointing a DPO? We operate as a franchise network. I'm unsure as to whether each individual franchisee needs to become a DPO, whether it's role for franchisor. The answer is not who's exempt. The answer to the question is much more who is mandated to appoint a DPO. DPOs have to be appointed by public authorities, by organizations processing large volumes of special categories of data in core business processes, or by organizations processing large volumes of data in a public place. For those organizations, a DPO is mandatory. For everybody else, it's voluntary. I would say almost certainly that none of your franchisees nor the franchisor need to appoint data protection officers. You may well need to appoint someone to be responsible for GDPR compliance. That's not necessarily going to be called a DPO. So do differentiate between a mandatory DPO and someone who's going to be responsible for GDPR compliance. The penalties for non-compliance are such that giving someone the job probably makes sense. Existing contracts, yes, need to be updated. While GDPR only applies from the 25th of May, it applies to everything you're doing from the 25th of May. So your existing employment contracts, your existing contracts with customers and suppliers and partners, all of them need to be updated. And you can have them go into force anytime you like before the 25th of May, but they need to be up to date by the 25th of May, or in reality, if you're running late, as quickly as you can thereafter. I am a small organization. We send out emails to our clients, our sales employees on their sales results. Do I need to send them an opt-in email to comply with GDPR? Probably not. It depends on the relationship that you have with your clients. Have a look at the lawful basis of processing in Article 6 of GDPR, see if one of those would apply, and whatever the option that applies is, you need to tell the data subject. You need to send them a privacy notice which sets out all of the information that Article 13 of GDPR describes. You mentioned DPIAs. DPIAs are pretty well mandatory for the same types of organizations as have to have data protection officers. That's the way to think of those. Plus, they're mandatory for organizations when you make changes to significant data processing activities, bring in new technologies and so on. A couple more questions. Does personally identifiable information extend to company data such as company email address? If the address is service center at IT governance, that's a company email address. It's not captured by GDPR. If it is Alan Calder at itgovernance.co.uk, yes, that is personal information because it identifies me specifically. Do you need consent to hold supplier or customer personal information if you have a trade relationship with them already? You don't necessarily need consent, you need a lawful basis. Back to Article 6, we need to keep financial records going back 7 years. No, this doesn't override GDPR consent. It's irrelevant GDPR consent because you have a statutory obligation to retain the record. So again, go back to Article 6. Article 6 has got a lot of key information. It's a very short article, but it gives you the options as to lawful basis of processing, and wherever you can find one that isn't consent, you want to apply that. If you can't find one that isn't consent, then consent is it. Don't have two of them of which one is consent, have only one lawful basis. We've got time for one last question, and there's a lot of work for a small business. There's only 3 of us. It's a full-time job. Yes, but bear in mind GDPR compliance is proportionate. You have to have a data protection policy. It doesn't have to be very long. You have to have a lawful basis for consent. That doesn't have to be complicated. You might not be doing very much. And you can apply GDPR in a way that's appropriate to your organization. And for a final question, before we run out of time, how will GDPR affect B2B businesses? It's exactly how it affects every business. Any personal data that you're processing is captured by GDPR, whether it's a work email address or a consumer email address, it's all subject to GDPR. I'm afraid, ladies and gentlemen, that brings us to the end of the allocated time. I'd like to thank you all for joining us. There is an ongoing series of webinars. If you go to our website, you'll be able to find a range of products and services that can help you. And I'd like to wish you all luck with your journey towards GDPR compliance. If we can help you, please do call on us. Thank you and have a good afternoon.